to the extent I can't handle it. Huh? Oh, God, no.
He's alluding to this very intimidating presence right here. Yeah. I'm trying to be at least.
I just realized I don't have my readers, so my notes may not be too. Anybody have a spare pair of readers I can?
No, I have not.
Huh? Are those prescription glasses? I don't think that's gonna work. I'll just have to read like this. Thank you, Mr. Chipmunk, Chairman.
This is going to be a really good look on the street.
It is. I figured certainly somebody would have one, but unfortunately I can't really talk because I ain't got mine, which I need essentially. Maybe I can have like.
I can't read that to you. I'm sorry.
No, I was thinking maybe if you held it, Deborah, I could read it from over there if you would hold it. Which one of these will this one? For the appointed hour, I understand.
Buddy might not show back up after the vote.
See, I believe the hour is here for us to get ready to go. I want to thank all of y'all that have ventured back into the committee room to serve on the committee. We had a long meeting, our first meeting, so it's good to see y'all all here. If I could call on Judge Scoggins to open us in a word of prayer.
Most kind and gracious Heavenly Father, we thank you for the opportunity to be here. We know that all things are through you and by you. Thank you for your grace and mercy. Give us wisdom in all the decisions we make today. In Jesus' name, amen.
Amen. All right, thank you. We are here for House Bill 80, and the author of the bill is a member of the committee, but we've got him sitting in the hot seat. So.
Don't make me come over there.
All right, I guess for the audience, if you would introduce yourself and then tell us about the bill.
Thank you, Mr. Chairman. I'm Representative Rob Leverett from Elberton, proud member of the Judiciary Committee. It's my pleasure today to present to you House Bill 80. I want to thank all the members of the committee for getting here at this early hour. I want to go ahead and tell you, if you take heart medication, go ahead and take it now, because we're about to talk about really high voltage, exciting stuff here. The Uniform Unsworn Declarations Act. It just sparkles and sizzles there. But I do appreciate you attending, and it is my pleasure to present this, and I'm very honored to be presenting this bill. We have a committee sub that we drew up over the last few days, and that should be in your folders. It's LC 49-1212S, and that was drafted in response to concerns the Association of Criminal Defense Lawyers expressed, and we can go into that a little later. But this does make just a few changes, mostly in where the statute is codified to achieve sort of a limitation of its application. The bill is supported by the State Bar and has been approved by the Board of Governors. And I want to thank Representative Oliver for co-sponsoring this bill with me. It would substantially adopt the Uniform Unsworn Declarations Act, which was adopted in 2016. We do have a few adjustments to them, which I'll highlight when I go through it. And what I'm gonna go through is review the bill line by line, and Rebecca Kolb is here with me to sort of talk a little more about the practical effect and why this is needed and how it will help. I'm not that familiar with unsworn declarations. Until she contacted me about the bill, I'd never really even heard of them. But I do think, upon educating myself, I think it's going to be a very helpful law and will be very useful, not only to practitioners, because it'll make getting a statement that's made under penalty of perjury, like a sworn statement, much easier. But I think it'll also help by making that process easier. Hopefully will help reduce the fees that some of y'all on the committee who may occasionally have to hire lawyers have to pay. And I think it's also very useful in international arbitration, which, as you know, is kind of vitally important in Atlanta now, because we're trying to position ourselves as a center for that. So this bill actually has an economic development angle to it. So, what I'll do is I'll try to go through here and review the line by. I'm sorry.
You're good.
Okay. Just please try to behave yourself, Representative. I will do the line-by-line review, which I am fond of saying, for which this committee has become known and has transcended the temporal and entered the realm of legend. So, and then if I have any questions, I may have to throw a lifeline to Rebecca to kind of help me. But so this basically takes what is sort of a mundane, almost overlooked, taken for granted legal procedure, and makes that process simpler and logistically easier while achieving substantially the same result, which is sworn statements. And I think that's important to focus on, because we as lawyers aren't often accused of that, but we're taking a more complex process and trying to make it a little simpler, but still achieve the same result substantively. So this bill basically introduces into Georgia law the concept of an unsworn declaration. That is, it is not sworn, but it is still made under penalty of perjury and has the same effect legally as a sworn statement and is equally admissible into evidence. And I know if you're like me, I have a small town practice. The whole notion of an unsworn declaration may sound a little unusual, because I don't do a lot of federal work, but for some of the members of the committee who practice in federal court often, my understanding is that's pretty common. It's very well accepted in the federal system, because there's been a statute, 28 U.S.C. 1746, since 1976, which provides for unsworn declarations. I even know I went on the internet, and there was an application for some kind of USDA program that was in the form of an unsworn declaration. So it's effectively under penalty of perjury, but you don't have to find a notary. So to kind of go through the bill a little bit, there's two sections to it. The first one amends Chapter 1 of Title 9. And unless my online version, I wasn't able to get in here and look at the books, unless my online version is wrong, I think we're going to make history, because to my knowledge, there ain't anything in Chapter 1 of Title 9 right now. It's empty. So this will actually place some law into that chapter. And we had initially, in the original version of the bill, if you notice, we were placing this in the evidence code, but to respond to some concerns of the criminal defense bar, we've moved it into Title IX to limit its application to civil actions. So that was the reason for placing it there. And effectively, what we've done is in one statute, or one code section, 911, we have adopted the various sections of the Uniform Act. You can sort of go through and track them. So what I will do is if I can just jump down to the bottom of the second page first. That's lines 35 through 38. And I sort of consider that to be the meat of the bill. Except as otherwise provided in paragraph 2 of this subsection, which has some exceptions, as it sort of indicates to you. If a law of this state requires or permits the use of a sworn declaration in a court, administrative or arbitral proceeding, an unsworn declaration meeting the requirements of this code section has the same effect as a sworn declaration. Now that sentence is chock full of defined terms that appear above on that page in line 17 to 29, law is defined very broadly. It's not only statutory law, but judge-made law and executive orders and administrative decisions. And then a sworn declaration and unsworn declaration are both defined above there in lines 26 through 29. And the definition itself contains two defined terms, which are record and sign. But a signed record under oath is a sworn declaration, and that includes sworn statements, verifications, certificates, and affidavits. Unsworn declaration is one that's signed but not given under oath, but is given under penalty of perjury, and that's kind of the key. It's still under penalty of perjury, which is, I think, the main purpose of having something be under oath. And the terms record and sign are defined so it includes not only tangible print media, but also electronic media, as long as it's retrievable and can be reviewed. So that's, and then in lines 31 through 34, we make it clear that the declaration can be signed either in this state or out of the state and still have effect in this state. So the exceptions are on the top of the next page, and that includes depositions, oaths of office, an oath required by statute to be given before some official other than a notary, oaths required in 9, 10, 1, 13, which are basically verifications of petitions and extraordinary injunctive relief and things of that nature, open accounts, and then an instrument expressly required by statute to comply with 44.215 are deeds, things that are going to be recorded in real estate records. So we're not applying this to the real estate practice. You still have to find a notary there. And then the oath required by 53.424 is the self-proving affidavit that you attach to a will. That still has to be done before a notary. 49 through 50 says if a law requires that the declaration be in a particular, that a sworn declaration be in a particular medium, you've got to do the unsworn declaration. So I'm assuming that's talking about electronic or paper. And then lines 51, I guess, down through 60, that's the actual format of the declaration. That's what has to appear at the signature, where you're notifying the person signing that they're signing under penalty of perjury. And then 61 through 63 are the standard uniform law saying that consideration will be given in construing this and making it uniform. And then 64 on through 67, there's Electronic Signatures in Global and National Commerce Act, and it generally preempts local law, but there is an exception to the preemption, which that portion is intended to fit into to say that this act is effective. Then in Section 2, we just modify the criminal statute on perjury, which relates to statements made in some kind of judicial proceeding, and we add the unsworn declarations as well. Those can constitute a violation of the statute, and this is a criminal violation. So I believe that sort of summarizes my review of the statute, Mr. Chairman, and I'm certainly want to answer any questions I can, although I may need to phone a friend.
Okay. Thank you for that explanation. So are there any questions by the committee? Who's got 13 over here? Representative Kelly.
Thank you, Mr. Chairman. Thank you, Representative Leverett. I guess my one question is, so now I know there's certain ways for authentication of other evidence. And so now instead of having to have, say, a medical records or other official, hearsay exceptions that require authentication by a notary, we can just do it with unsworn declaration. That's how it'll fit in practically here.
That's my understanding of how the statute would operate, yes, sir.
Okay, thank you.
All right. Anything else? Oh, I'm sorry. Is it Representative Silcox or Bruce?
Yes.
I can't get the
Yes,
numbers right.
yes.
Okay, go ahead.
I think this is me. Thank you, Mr. Chairman. I was just curious, could there be an oral unsworn? Okay, that's my worry is, would there be evidentiary problems with someone saying the magic words but not having it?
Is the microphone?
Yeah,
okay?
go ahead.
It has to be it has to be written
Okay,
and
has to be
conform
written.
with the requirements in that line items that Representative Leverett went through, and it has to be a signed statement under
Okay.
penalty of perjury.
Okay, thank you.
I will admit that when the State Bar came to explain this concept to me, my prosecutor brain went into effect, and I'm like, you're just inviting people to come in and lie about all this stuff. So I'm understanding the concept a little better now, and glad to know that it has been in practice in the federal system. Of course, that could be what's wrong with our federal government.
Don't say things like that when I'm presenting my bill, Mr. Chairman.
All right. Do you want to make a statement, or?
I think she did want to testify, yes, sir.
Okay, all right.
I'm here. It'd be weird
You can
not
use
to
that
at this
microphone
point, I
there if you
guess.
want.
We'll work, here, I'll scoot out of the way.
Just introduce yourself, and if you have an organization you represent, let us know that, and then make your statement. So.
Yes, of course. My name is Rebecca Kolb, Kolb. I am a practitioner in the city. I've been practicing for a little over a decade now, and I practice in litigation. I am here on behalf of the Atlanta International Arbitration Society. I'm the president-elect for that organization, and my tenure will take effect in May. And the reason that we are advocating for this bill is the economic development point that Representative Leverett brought up. The entire mission behind Atlas is what we refer to ourselves as, is to increase the profile of Atlanta for international arbitration. And this bill will allow for the same type of statements that Representative Leverett explained to be used for foreign declarants as well, which is actually a very large logistical hurdle for any U.S. person that is trying to make a sworn statement in a foreign country. They have to actually make an appointment at a consulate, a U.S. consulate office, get through security, and have an officer there notarize their statement. So this streamlines to a much greater extent the statements for foreign declarants, which we hope would, is that going to be the reason that Porsche decides to expand in Georgia? Probably not. But is that going to maybe remove some of the barriers that international companies might see to doing business in the state? Hopefully it does. There's, several practical benefits for practitioners in the city as well, and the clients of those practitioners, as Representative Leverett already stated. It actually, for once, streamlines the process in litigation and will, just make lives easier for everyone that this impacts, which is a very finite group. It's not going to impact every constituent, but for those that it will make life easier. And to the extent we can do that, I think that it's a good thing.
Do you know how many other states have adopted unsworn declarations?
So this particular bill is a new uniform law. I think it was only promulgated in 2018, maybe 2016, and so there are only 4 other states that have adopted this exact version, but there are, I think, around 20 that have done the one that applies solely to the foreign declarants. And there's also one for domestic declarants, and I can't give you the number exactly on who else adopted that.
May I also say something, Mr. Chairman?
Swing that over to, yeah.
According to some of the information on the Uniform Law website, there are about 22 other states that allow unsworn declarations, although they haven't adopted this specific act. So again, while it's new to me, apparently ain't new to most of the world. This would sort of put us in. It's not like we're going to be an outlier on the point of some new kind of fancy fad legally.
Sure.
And I will also make the note here that, as Representative Leverett stated, this is the practice in federal court, which includes every district court in the state of Georgia. So practitioners in Georgia already have this practice. And as someone who has practiced in both federal and state courts very frequently, it's actually a point of, oh no, I'm in state court. I have to find a way to get this statement notarized. So it's something that that is practiced, not everyone, all practitioners in the state of Georgia that have practiced in federal courts are very familiar with this process.
Okay, thank you. Representative Oliver.
Many of you may remember that the state invested some money into the arbitration center at Georgia State. It was designed to be used as it's being used now internationally by folks coming to Georgia from business entities from particularly Africa and South America, but also are using that facility. It's facilitated this unique section of the bar. we passed, we were just talking over here, a statutory power of attorney that says it has to be signed before a notary. That was a statute we passed 3 or 4 years ago. Is that an example where this statute would eliminate that notary, or is it an example where that statute requires a notary?
Is the power of attorney requirement in the Civil Practice Act for use within court proceedings?
It is independent. It's just we
It's in the agency
executed
file.
a separate power of attorney form for consumer protection reasons. There are probably several of you that remember that bill.
Okay, it will only apply to bills that are for, it applies to sworn statements to be used in court proceedings, administrative proceedings, and arbitral proceedings.
Well, a power of attorney is subject to litigation would be in court. It sounds to me like, well, I'm not sure what the impact would be.
Just from my extensive study of the bill last night between the hours of 9 and 10:30, I don't believe this would alleviate that requirement.
Right.
Although you might be tendering that into court, the document itself to be effective has to be notarized. So I think this is, again, intended to be limited to court proceedings or something like that, like an arbitration or an administrative hearing.
So if I take the power of attorney to the bank, they're not going to accept it if it's not notarized. If I try to tender it into court, if it's in dispute, it might be.
Can't speak to the bankers. I don't know how good their lawyer is, but
Their
they should not.
banks
anyway,
are
no.
Tough character.
Couldn't you introduce the copy of the affidavit by that in litigation if you were?
Yes, this does not remove the effectiveness of affidavits. That was very intentional. Notarized affidavits are still available and still very necessary in certain parts of other sections' practices, and that's actually a modification we made to the bill and getting it through the state bar and through approval for the Board of Governors. The real property law section was worried that it was unintentionally not carving out enough of the real property law statements. And so they had asked us to make an edit to make sure that we were broad enough to do that. And so that's an intentional edit that we made. And we were and their requested edit was actually to make sure we already had the carve out for, I think it was Title 44. Thank you. Your studying was very well done. We already had the carve out for Title 44, but that's when they asked us to put in the additional requirement of it to be used in court, administrative, or arbitral proceedings, to still maintain protections to allow for the use of affidavits when it is necessary.
Mr. Chairman, well, just one other comment. In my probate practice, I had to take an oath in Africa, and the term notary in the European system and the African system is that it's more like a lawyer.
Mm-hmm.
And it cost me $800 when he found out I was from Georgia, USA, instead of Georgia, Russia. The fee went from $400 to $800, which I thought was probably fair, but it was an unusual experience for me. It took a day and $800.
I just, Mr. Chairman, I forgot to point out to Rebecca's point, on line 36, the words "in a court, administrative, or arbitral proceeding," that's lines 36 and 37, that does not appear in the Uniform Act. That was one of the edits that were made to try to limit the scope of the law to
Right.
just, legal, judiciary, and quasi-judiciary proceedings.
Applied everything that we want it to apply to without unintentionally including something that still needs that still, for some reason, needs the protections of a notary behind it.
Okay, very good. Chairman Smith?
Thank you, Mr. Chairman. Thank you for the bill, Chairman Leverett. We talked about 22 states having already passed something similar to this. Has Alabama or Florida passed this?
I don't believe they have passed the Uniform Act.
No, they have not.
Alabama, Mississippi, Tennessee, South Carolina, North
I
Carolina.
don't think so. The states that have passed the Uniform Act tend to be out west. And I don't know actually the states that allow for unsworn declarations, and I actually haven't researched that myself. That was just in the comments. Sorry, I didn't research that statement myself. That was just in the comments to the Uniform Act.
Sure. So,
To the extent there is any concern regarding potential political implications for this bill, it is not a political bill. It is bipartisan. It has equal impact to all sides of the bar. equal benefit to all sides of the bar, plaintiff's bar, defense bar. Everyone that needs a witness to provide a sworn statement is going to equally benefit from this without having any type of unintended benefit more to one side than the other.
Okay. Second question, if I may,
Yes, sir.
Mr. Chairman. Recently run into an issue with notarization of a document, and of course this is mainly in probate, and so it's not necessarily going to be affected by this. However, having run into an issue with notarization of a document concerning testamentary capacity, and just, I mean, let's be honest, we know there's abuse of notarized, or of document being notarized, and the duty that a notary has placed on them by law. Maybe we need to educate them a little bit better than what we do. Long story short, with the issues we already have with notarized statements, is there any concern this could continue to be a issue with unsworn?
I mean, I would say I don't view that to create that issue. I think that issue is going to exist as long as you have a written statement of any type.
Okay. All right. Thank you.
And Representative Bruce.
For the non-lawyers in the room, all of this that we've just talked about says you cannot tell a lie, and if you do, you're going to be under the same penalty as if you were sworn. Is that what this is saying?
That's
Okay.
exactly it, yes.
Thank you.
Thank you.
Once again, Representative Bruce brings clarity.
Yes.
to an otherwise muddled presentation.
I agree with that. That looks like that's all the questions. Do we have anybody else that wants to speak on this bill?
Can't believe we don't have a big crowd, Mr. Chairman.
Not like the other day, right? No,
Yeah, I know.
standing room only. All right. Oh, did you have?
Since we have nearly a room full of people from various sectors of the legal community and all that, and since they have no opposition, since we've had a thorough presentation, at the appropriate time, I have a motion, Mr. Chair.
All right. This probably would be the time to do it.
I move do pass.
I have a motion and a second. Any discussion on the bill? I'm sorry?
On committee sub.
Oh, yes. On committee sub, LC 491212S. All right. All those in favor of passage of this bill say aye.
Aye.
Any opposed? All right. Bill passes.
Thank you, Mr. Chairman. Thank you, members of the committee.
All right. We're
Appreciate your
adjourned.
attention.
Thank
I'm
you.
gonna go